Hello to everybody, this is Dr. Maryam, and as usual would like to share a couple of legal advices, and this time I would like to talk briefly about confidentiality. What is the meaning of confidentiality, and what kind of documents can have confidential point or confidential clause? What is the responsibility for breach of the confidential point, and what can be done in the UAE, what is the level of responsibility, what is the procedure. So first of all, confidentiality is the point where some kind of information has a limited grounds to be shared. So you can have confidential conversation, you can have confidential messages and confidential meeting, you can have confidential agreement, or some documents related to the agreement or related to any kind of dealing between the parties. And of course, if you see that, for example, in the email that you receive, there is a point that this email is confidential. So basically, you don't have a right to disclose it, to share it, to send it, or to discuss this information with somebody else, especially with the parties who are related, for example, to this kind of dealing or conversation, or the party who is against, for example, if we are talking about the claim, existing claim or possible future claim. If we are talking about agreement, it also can be confidential. And of course, if you want to keep your dealing confidential, you have to write properly about this, that this kind of agreement or contract has confidential point or confidential meaning, and for any kind of sharing of this information or maybe public expression of this information might have future breach of full contract or maybe part of the contract, or can be a reason for the termination, and also there will be damages. Also, not only the agreement can be confidential, it can be any kind of document. For example, in your company, some information might be kind of secret. So, for example, between you and your employees, between the management of the company, between the shareholders, anything can be actually confidential. But of course, it should be properly arranged, it should be properly written in the document, and you should also put more value. You should write what will be the level of responsibility. So, for example, for breaching of this, there might be, let's say, responsibility for the damages in amount of 50,000 or amount of 10,000, anything, what you consider will be properly to claim for the damages, because otherwise it will be difficult in future to prove it. So, for example, if somebody decided to breach confidentiality and shared the document or shared an information that was confidential, what to do and what possibly can be done. Of course, you should make an action, and definitely you should prove what kind of damages this disclosure, this information cost for you. For example, your employee took some secret information, left the company, took, for example, database of the company. Was it confidential? If it was confidential, of course, you can claim for this. You can tell that your employee do like this, and he is liable for your breach. If it was not confidential in your opinion, then this will be a different part, and you can also claim for damages, but this is totally a different story. So anything that has confidential meaning should be properly arranged and should have a meaning, a point that it's confidential. For example, you have a contract between you and the other party, and it's written that it's confidential. After you see that on social media, for example, this your second party discussed your agreement and discussed some terms, is it right? Of course, no. So you can actually prevent this if you don't want to make it public, or you actually don't want any kind of awareness about this dealing. The breach of the confidentiality itself, you should always put the value with the damages that you had. So, for example, why you think that you have a right on compensation in this amount? Why you have a breach? Why you have damages? What happened after this information was disclosed? So if there is actually any point, any meaning of this, not only a legal point that it was confidential and I don't know now what I will do as this information is disclosed. No, you should actually explain what are the damages, why it makes for you, for your party, for your company, any problems. So of course it can be possible through the active claim. You can go ahead with a commercial case, or if you are having a company, of course it will be a commercial case. So you can explain to the court what are the damages, and you can always present a proof, and of course you will have a positive judgment in your favor, and the other party will be liable for the damages. On the top of this, you can, for example, ask to delete something, to delete an information that was disclosed, to oblige the other party not to do it in future, to delete it from some particular services or social media or whatever. So you can have a lot of options if this really makes for you a problem. So confidentiality is really a very important point. Unfortunately, not everybody is using it. Not every contract has confidential point. Sometimes even we with the dealing with our clients or with possible clients, we hear from the people, can you keep it confidential? Actually, any meeting with the lawyer is confidential, but sometimes even the clients, they are asking to keep everything confidential because they want to keep it in secret and not to disclose it, to have guarantees that it will be actually not in public. But if we are talking about the dealing between the parties or between the individuals, even in your own company, if you are employer or you have some dealing with employees, or if you are employee and you have any relationship with the company where you have position and you are doing something valuable and this might be disclosed. So you should always be careful with the document that you will assign or you already assigned, and to be careful with discussing of the information. So if you are actually already, for example, unfortunately disclose some information, you can always prevent it. For example, you can delete it, you can erase this information, you can try to avoid some damages. And of course, before the claim, you should actually discuss with the other party if you see that you've done a breach. It's always recommended to negotiate to prevent the claim and not to go ahead with the court trials, because if the other party has enough proof, you will definitely be liable. The level of responsibility is always a question mark. If it's not written, for example, in a particular document or agreement that for disclosure of the information you will be liable, for example, for amount of 50,000 dirham, then it will be really difficult to prove the amount exactly, not the breach. The breach will be maybe easier to prove, but the amount that that is in the link with the damages is always a very difficult point, even for the lawyers. So here you can fight. You can actually reduce the amount, or maybe you can make it very small as a compensation. I hope this video was useful for you all. If anybody has questions in regards of confidentiality or any other questions, please go ahead with your comments, your questions, or maybe somebody had experience. Be careful, don't break the law, don't make anything that will put you on bad side or difficult side of the law. Thank you so much everybody for your attention. Hope you are all safe. Please take care. Have a lovely afternoon. Goodbye.